On September 20th, 2024, the state of South Carolina executed a man by lethal injection. It was the first time South Carolina had killed anyone in 13 years. Pause. 4 days later, on the exact same day, two men were executed in two different states, hours apart, different prisons, different methods, same Tuesday. Pause. 2 days after that, two more, different states. One of them was killed with a gas mask over his face. Witnesses said he shook for 2 minutes and gasped for 6 more. The state called it humane. 5 executions, 5 states, 6 days. In one of those cases, the prosecutors who originally convicted the man were standing in court the day before his execution, begging the judge to stop it. They said they got it wrong. The court said it did not matter. The governor agreed. They killed him anyway. Silence. 3 full seconds. This documentary is about all 5 of them. Not just the crimes, not just the executions, but the full, uncomfortable, maddening story of what happened in 1 week in America. A week that the news cycle swallowed whole and spat out like it meant nothing. It meant something, and by the time this is over, you will know exactly what. Case 1. Alan Eugene Miller. On the evening of September 26, 2024, inside an Alabama execution chamber, a 59-year-old man named Alan Eugene Miller was strapped to a table. A mask was placed over his face. Not a sedation mask, not an anesthetic, a nitrogen gas mask, designed to flood his breathing space with pure nitrogen, stripping every molecule of oxygen from his lungs until his body had no choice but to shut down. The witnesses in that room, the journalists, the officials, the observers, legally required to be present, watched what happened next, and what they described afterward bears absolutely no resemblance to the word Alabama kept using to justify this method. That word was humane. For approximately 2 minutes, Alan Miller's body shook against the restraints, holding him to the table. He pulled, he trembled, his chest heaved in the way. The chest heaves when the lungs are searching for something that is no longer there. Then, for the next 5 to 6 minutes, witnesses watched him gasp, intermittently, repeatedly, his mouth working against the mask, his body doing what bodies do when they are being deprived of oxygen, and every biological alarm system they contain is screaming at once. Alabama's Attorney General issued a statement after the execution. He described it as proceeding without incident. Let that sit with you for a moment. 2 minutes of shaking, 6 minutes of gasping. A man visibly fighting against what was happening inside his own body, and the official position of the state of Alabama was, no incident occurred. This was not the first time Alabama had used nitrogen hypoxia on a human being. That distinction belongs to Kenneth Eugene Smith, who was executed in January of 2024, 9 months before Alan Miller, and whose witnesses described almost identical scenes, convulsing, straining, a body that did not go gently at all. Alabama said that one went fine too. So when we talk about Alan Miller, we're not just talking about one execution, we're talking about a pattern, a method that 2 different sets of witnesses in 2 different executions, months apart, described in nearly identical terms, and a state that looked at both those descriptions and said, we see nothing wrong here. Before we go any further into what happened in that chamber, you need to know who Alan Miller was, what he did, and why he was on Alabama's death row in the first place. Because this story, like all the stories in this documentary, does not begin in a prison. It begins with people who were alive, who had jobs and families and Tuesday mornings, and who ended up dead because of decisions someone else made. It was August 5th, 1999, a Tuesday, Pelham, Alabama. The kind of humid southern summer afternoon that sits heavy on everything. Alan Miller, then 34 years old, drove to a business called Post Sorting, where he had previously worked. He walked inside, he had a gun, he shot and killed Lee Holbrooks. He got back in his car. He drove to a second business, Ferguson Enterprises. He walked in, he shot and killed Christopher Yancey. He got back in his car again. He drove to a third location, another business called Accurate Air Engineering. He walked in, he shot and killed Terry Jarvis. 3 men, 3 different locations, one Tuesday afternoon. Lee Holbrooks, Christopher Yancey, and Terry Jarvis did not know, when they went to work that morning, that it was the last morning they would ever have. They were simply people doing their jobs. Ordinary, unremarkable, valuable human beings, living the kinds of lives that never make the news until something catastrophic happens to them. The motive that prosecutors presented at trial was one of the most chilling things about this case, not because it was elaborate or sinister or hard to understand, but because it was so devastatingly small. Alan Miller believed these men had been spreading rumors about him, workplace rumors, the kind of low-level, petty social friction that every person who has ever worked anywhere has encountered at some point in their life. 3 men died because of that. 3 families were permanently, irrevocably broken by the decision of a man who responded to office gossip with a gun in 3 separate drives across Pelham, Alabama. Miller was arrested. The evidence was overwhelming. He was convicted on 3 counts of capital murder and sentenced to death. And here is where Miller's story adds a layer that almost nobody covered at the time of his execution. The path to his death was not straightforward. In 2022, Alabama had already attempted to execute Miller by lethal injection. That attempt failed, not because of a legal stay or a last-minute court order, but because the execution team could not establish adequate IV access. They tried for over an hour to find a vein. They could not. The execution was called off. Miller was taken back to his cell, alive, because the state literally could not find a working vein. Then Alabama scheduled him again, this time with nitrogen. His lawyers went back to court. They argued, and this argument was not frivolous, not a desperate last-ditch legal Hail Mary, that executing a man twice, subjecting him to the trauma of lying on an execution table believing he was about to die, and then not dying, and then strapping him down again, months later, to try a completely different and scientifically untested method, constituted cruel and unusual punishment under the 8th Amendment of the United States Constitution. The courts denied the appeal. And so on September 26, 2024, Alan Miller lay on that table for the second time. Except this time, instead of an IV line, there was a mask. And instead of lethal injection drugs, there was nitrogen. Now let's talk about what nitrogen hypoxia actually does, because Alabama has been very deliberate and very careful about how it frames this method, and the framing does not match the science. Nitrogen makes up roughly 78% of the air we breathe every day. It is not a toxin, it does not burn, it does not poison. What kills you in a nitrogen hypoxia execution is not the nitrogen itself. It is the complete and total removal of oxygen from your breathing environment. The mask delivers pure nitrogen, and as the oxygen in your lungs and bloodstream drops, your body begins to fail. Alabama's argument, the argument they presented to courts, to the press, to the public, was that this process causes rapid, painless unconsciousness before the person can register any distress. They pointed to cases of high-altitude pilots who lost oxygen suddenly and reported afterward that they felt nothing, just a quiet fade. Multiple anesthesiologists and medical scientists have formally objected to this comparison, and their objections deserve to be heard clearly. The pilots Alabama referenced were not conscious and psychologically aware of what was happening to them. They were not restrained on a table. They were not in a state of acute terror-level psychological stress. They were not human beings who had just been told that in 60 seconds a mask was going to be placed on their face and they were going to be killed. Alan Miller was all of those things. And the science of what happens to a fully conscious, psychologically stressed, terror-activated human being during acute oxygen deprivation through this specific mechanism is not settled. Researchers who have studied this have raised serious, credible, published concerns about whether the initial phase, before unconsciousness arrives, involves a period of genuine distress that the person cannot communicate because the nitrogen is already affecting their cognitive function. What that means in plain language is this: the person on the table may be suffering during a window that looks from the outside like quiet unconsciousness. You could watch someone go through genuine agony, and it could look through the glass of a witness room like sleep. Alan Miller shook for 2 minutes and gasped for 6. His last words, spoken before the mask went on, were, "I didn't do anything to be in here." 25 years after shooting 3 men in cold blood at 3 separate locations on a Tuesday afternoon, still claiming innocence. Lee Holbrooks, Christopher Yancey, and Terry Jarvis did not get to claim anything. They did not get 25 years. They got a Tuesday in August and then nothing. Whatever happened in that Alabama chamber on September 26th, whether Miller suffered or whether Alabama is right that it was as peaceful as they claim, the 3 men he killed suffered first. That is the fact that has to be the foundation of everything else in this case. But the question of whether a state can strap a man down and fill his lungs with an experimentally applied gas and call it humane, while witnesses describe something that looks nothing like what they promised, that question does not go away just because the man deserved to be punished. It does not go away, and Alabama has not answered it. Alan Eugene Miller was pronounced dead on September 26, 2024. He was the 5th execution of that week. But he is the first story in this documentary because what happened in that Alabama chamber, the shaking, the gasping, the official statement calling it incident-free, is the image that holds this entire week together. It is the image that tells you everything you need to know about the gap between what the American justice system says it is doing and what it is actually doing. 5 states, 6 days, and in an Alabama execution chamber, a man with a mask on his face, fighting for air that was never going to come. We are just getting started. Case 2. Freddie Eugene Owens. 4 days before Alan Miller gasped under a nitrogen mask in Alabama, a different state flipped a different kind of switch. September 20th, 2024, Columbia, South Carolina. The state of South Carolina executed Freddie Eugene Owens by lethal injection at 6:55 p.m. He made no final statement. He was pronounced dead. The witnesses left. The press released their reports. And South Carolina became, in that moment, a state that executes people again. The reason that sentence matters, the reason it cannot just slide past you, is this. South Carolina had not executed a single person in 13 years. 13 years. The last execution in South Carolina before Freddie Owens was carried out in 2011. For over a decade after that, the state had a death row full of men whose sentences sat uncarried, not because the state had changed its position on capital punishment, not because the legislature had passed a moratorium, not because any grand moral reckoning had taken place, but because South Carolina could not obtain the drugs it needed to kill people. The same pharmaceutical company crisis that pushed Alabama toward nitrogen had in South Carolina simply produced paralysis. European drug manufacturers, operating in countries that abolished capital punishment generations ago, withdrew their cooperation from American prison systems. They did not want their products used in executions. Supply agreements were canceled, and South Carolina, unwilling to adopt alternative methods, simply stopped executing people, while the legal and logistical arguments dragged on. Then, in July 2024, the South Carolina Supreme Court ruled the state's death penalty protocol constitutional. And within weeks, they had an execution date. Freddie Owens was first. Not a machine, not a policy, a person. Freddie Eugene Owens was convicted of murdering 41-year-old Irene Granger Graves on November 1st, 1997, in Greenville, South Carolina. Irene Graves was at work. She was 41 years old, doing what millions of people do without a second thought. Going about an ordinary workday, when a robbery went fatally wrong, and she was shot and killed. She was 41. She had a life. She had people who loved her. She had mornings and plans and things she was looking forward to that she never got to reach. Freddie Owens was convicted of her murder. He was 20 years old at the time of the crime. He was sentenced to death and placed on South Carolina's death row, where he waited and waited. Through South Carolina's 13-year execution drought, he waited, never knowing whether the sentence hanging over him was ever actually going to be carried out, or whether the state's logistical and legal problems would keep him in a legal limbo indefinitely. 27 years passed between Irene Graves' murder and Freddie Owens' execution. 27 years. Owens arrived on death row as a 20-year-old. He was executed at 46. The man who walked into that execution chamber had spent more than half his entire life inside a South Carolina prison, waiting for a sentence to be carried out that the state had temporarily lost the ability to enforce. There is a question embedded in that timeline that nobody in the official conversation around this execution asked publicly, and it deserves to be asked here. What does it mean for justice when it arrives 27 years late? Not from the perspective of the convicted. Owens killed someone. He was tried, convicted, and sentenced by a jury. Whatever one believes about capital punishment in the abstract, the legal process in his case followed the arc it was designed to follow. But from the perspective of Irene Graves' family, from the perspective of the people who buried her in 1997 and spent the next 27 years watching the legal system churn, what did this execution actually deliver? Did it deliver closure? Does closure arrive 27 years after a loss and feel like the thing that was promised? Or does it feel like the end of a very long, very exhausting ordeal that the system created and the family had no choice but to live inside? These are not comfortable questions. They are not questions that have clean answers, but they are the questions that Irene Graves' family alone can answer, and the rest of us have no right to tell them how to feel about September 20th, 2024. What we can say is this: South Carolina restarted its execution apparatus after 13 years of silence, and the first person they chose to restart it with was a 46-year-old man who had been on death row for over a quarter century. That is not justice delivered swiftly. That is a system finally getting around to finishing what it started, and doing so on a political and logistical timeline that had nothing to do with the urgency of anyone's grief. Freddie Owens made no final statement. After 27 years on death row, after watching the state argue about drugs and methods and constitutionality while he sat in a cell, he had nothing left to say. Or perhaps he had too much to say and no words felt adequate. Or perhaps, after all that time, silence was simply the most honest response to everything the system had put him through. The pentobarbital was administered. At 6:55 p.m., he was pronounced dead. And South Carolina's execution machine, dormant for 13 years, was running again. 2 days later, it would be running in 4 other states simultaneously. And one of those states was about to execute a man whose story is unlike anything else in this documentary. A man who did not fight his execution. A man who had killed his own infant son, driven to Galveston, Texas, and left the baby's body on a seawall. A man who called what was coming assisted suicide. Case 3. Travis James Mullis. There is a specific kind of silence that falls over a room when you tell someone what Travis James Mullis did. Not the silence of shock, not the silence of disbelief. The silence that happens when the human mind encounters something so far outside the boundaries of what it can accept that it simply stops, briefly, and tries to reorganize itself around information it does not want to hold. Travis James Mullis murdered his 3-month-old son. His name was Elijah. He was 3 months old. On January 27, 2008, Travis Mullis, then 22 years old, had an argument with his girlfriend in Galveston, Texas. After the argument, he took his infant son, got into his car, and drove to Seawall Boulevard, one of Galveston's most recognizable stretches of road, running along the Gulf Coast seawall. What happened on that seawall is the kind of detail that does not get easier no matter how many times you read it. Mullis strangled Elijah. Then he stomped on the baby's head. Then he left the infant's body on the seawall and drove away. Elijah was 3 months old. He had been alive for approximately 90 days. He had not yet learned to sit up on his own. He could not talk. He could not walk. He was entirely, completely, and in every possible sense, dependent on the adults around him for every aspect of his survival. And the adult responsible for him drove him to a seawall on a January night and killed him. The body was found. The investigation led to Mullis quickly. He was arrested, tried, and convicted of capital murder. In 2011, he was sentenced to death. And then Travis Mullis did something that almost no condemned person in the American legal system ever does. He waived his appeals. All of them. Not one, not some. Every legal avenue available to him, every motion, every petition, every habeas argument, every constitutional challenge, he waived. He told the legal system, in the clearest terms available to a death row inmate, skip it. I am not fighting this. Do what you're going to do. His legal team and mental health advocates raised serious concerns. Voluntary execution waivers by death row inmates have been studied by criminal psychologists for decades, and the findings are consistently troubling. Experts argue that a meaningful number of these waivers are not expressions of genuine, autonomous decision-making. They are expressions of severe, untreated mental illness, of depression so profound that the person has lost any functional will to live, of a psychological state that is categorically different from the kind of clear-headed rational choice that courts expect when they accept these waivers. Whether that was true for Mullis, whether his decision to waive his appeals was the product of genuine reckoning or profound psychological collapse, is something the legal system was not required to determine before accepting the waiver. It accepted it. The appeals were waived. The execution proceeded. On September 24, 2024, Travis James Mullis was executed by lethal injection at the Huntsville unit in Texas. He was 38 years old. His final statement, the last words he was given the opportunity to say, described his own execution as a form of assisted suicide. That phrase, assisted suicide, sit with it for a moment, because it opens a door that the official legal and political conversation around this execution sealed shut and moved past very quickly. Assisted suicide, in the jurisdictions where it is legal, where it is practiced, where it is debated, is understood as an act of mercy. It is the provision of death to someone who is suffering, who has no prospect of relief, who makes an autonomous, considered, fully informed decision that they want to end their life. It is surrounded by medical oversight, legal safeguards, psychological evaluation, and waiting periods designed to ensure the decision is genuine. What Travis Mullis experienced on September 24, 2024, was none of those things. He was not suffering from a terminal illness. He was not in unmanageable physical pain. He was a man convicted of one of the most violent and morally indefensible acts that one person can commit against another: the murder of a helpless infant, who had, at some point in his 16 years on Texas's death row, decided he did not want to live anymore and found a way to use the machinery of the state to act on that decision. Is that justice for Elijah? That question does not have a clean answer. Elijah cannot be brought back. The 3 months of life he was given cannot be extended retroactively. Nothing that happens to Travis Mullis in a Huntsville execution chamber changes what happened on that Galveston seawall in January 2008. But the question of what it means to execute a man who is actively seeking his own death, who has, in a very real sense, engineered his own execution by refusing to fight it, sits uncomfortably at the intersection of justice, punishment, and something that starts to look, at certain angles, more like accommodation than accountability. Texas was not punishing Travis Mullis by executing him. Travis Mullis wanted to be executed. Texas was, in the most literal possible sense, giving him what he asked for. Whether that is justice for Elijah or simply the path of least resistance for everyone involved is a question that the state of Texas did not spend much time with. Elijah's mother, Mullis's former girlfriend, has lived with what happened to her son for 16 years. She has had no choice but to carry that. No one asked her whether her version of justice looked like an execution that the killer described as mercy for himself. Travis Mullis was pronounced dead on September 24, 2024. Elijah was 3 months old. In the same hour that the state of Texas was administering the lethal injection to Travis Mullis in Huntsville, a few states to the northeast, in a Missouri execution chamber, another man was being strapped to a gurney. His name was Marcellus Williams, and his story is the reason this documentary exists. Case 4. Marcellus Scott Williams. The day before Marcellus Williams was scheduled to die, the prosecutors who put him on death row walked into a Missouri courtroom and asked the court to stop the execution. Read that again? The prosecutors, the people who built the case, the office that stood before a jury and argued successfully that Marcellus Williams deserved to die for what he had done. Those same people, or at least their successors in that office, who had reviewed the case and looked at what they found, filed a motion asking the Missouri Supreme Court to halt the execution. They said the case had problems, serious ones. The court denied the motion. The governor rejected clemency. The U.S. Supreme Court declined to intervene. And on September 24, 2024, at 6:01 p.m., Marcellus Williams was executed by lethal injection in Missouri. He was 55 years old. No one from the victim's family attended. To understand why what happened to Marcellus Williams is the most important story in this documentary, you have to understand who Leisha Gale was and what was done to her. Because her story, the crime at the center of all of this, has to be told clearly and fully, not as a legal backdrop, as a human reality. Leisha Gale was a former newspaper reporter. She lived in a suburb of St. Louis, Missouri. She was a professional, a person with a career and a community, and a life that was built on years of work and choices and relationships. On August 11, 1998, someone broke into her home. She was stabbed, not once, not twice, 43 times. 43. The sustained, repeated nature of that violence is something that does not process easily. This was not a quick crime. It was not an impulsive, momentary act of violence that was over before the perpetrator understood what had happened. It was prolonged, brutal. It required someone to keep going repeatedly against another human being who was trying to survive. Leisha Gale deserved to live. She deserved every year that was taken from her, and the person who killed her deserved to be found, prosecuted, and held fully accountable for what they did in her home that August. Marcellus Williams was convicted of her murder. He was sentenced to death, and he spent the next 26 years on Missouri's death row. The case against Williams was built substantially on witness testimony and circumstantial evidence. There was no physical evidence at the scene that forensic testing at the time definitively linked to him. Years later, after Williams had already been on death row for years, DNA testing was performed on evidence from the crime scene, including the murder weapon, the knife, the object that was used to stab Leisha Gale 43 times. Williams' DNA was not on it. Someone else's DNA was an unknown male profile, unidentified, not Williams. Now, to be clear about what this means and what it does not mean, because the state's counter-argument deserves to be heard, DNA absence from a murder weapon is not automatic proof of innocence. Killers wear gloves. DNA degrades over time. Secondary transfer can produce unexpected profiles. A skilled prosecutor can, and in this case did, argue that the unknown DNA profile on the knife was explainable through means that had nothing to do with Williams' guilt. That counter-argument is real. It is not dishonest. It is a legitimate legal position. But here's the thing about legitimate legal positions. They're supposed to be weighed. They are supposed to be examined by courts with the full record in front of them and adequate time to reach a considered conclusion. That is what the justice system is designed to do. That is the purpose of post-conviction review, in capital cases specifically, because in capital cases, unlike any other, there is no correcting a mistake after the sentence is carried out. The St. Louis County Prosecutor's Office reviewed the DNA evidence. They reviewed the original trial record, and they concluded, officially, in writing, as a matter of prosecutorial judgment, that the questions raised by the DNA evidence were serious enough to warrant a new hearing. They filed a joint motion with Williams' own defense team to vacate the conviction and hold a new evidentiary proceeding. Think about how extraordinary that is. Defense and prosecution filing together. The two sides of an adversarial system united in asking the court to take another look. The Missouri Supreme Court said no. The procedural rules governing post-conviction challenges, the court ruled, had not been satisfied. It did not matter that the prosecutors wanted a new hearing. It did not matter that new DNA evidence existed. The procedural clock had run out. The execution was allowed to proceed. On the morning of September 24, 2024, Williams' legal team made one final attempt, an emergency application to the United States Supreme Court, asking for a stay of execution while the DNA questions were reviewed. The Supreme Court denied it. Governor Mike Parson, who had the unilateral authority to grant clemency and stop the execution regardless of what any court had ruled, declined to do so. At 6:01 p.m., Marcellus Williams was administered the lethal injection. He maintained his innocence until the end. The victim's family, Leisha Gale's family, did not attend. Their absence from the execution chamber of the man convicted of killing their loved one is not a small detail. Families of murder victims attend executions. It is one of the things the justice system tells them they're entitled to. The closure, the witness, the formal marking of the ending. When a victim's family does not attend, it means something. In this case, Leisha Gale's family had reviewed the DNA evidence and the prosecutor's motion. They had their own position on what the evidence meant. They were not present when Marcellus Williams died. Here is the question that September 24, 2024 left behind. Permanently, irreversibly, because there is no going back now. Did Missouri execute the right man? No court has definitively answered yes. The courts that allowed the execution to proceed did so on procedural grounds, not on a full review of the DNA evidence and its implications. The prosecutors who built the case against Williams were not the ones who reviewed the DNA and concluded the questions were too serious to ignore. The governor who rejected clemency did not engage publicly with the substance of the DNA questions. The system moved, the execution was carried out, and Marcellus Williams is dead. If he was guilty, if the original jury was right, if the DNA evidence can be explained away, if every argument his lawyers made was ultimately wrong, then a man who stabbed a former newspaper reporter 43 times in her own home received the sentence a jury gave him. But if he was not, if the DNA on the knife means what his lawyers said it meant, if the unknown male profile belongs to the actual killer, if the witness testimony that convicted him was unreliable, then on September 24, 2024, the state of Missouri executed an innocent man and moved on. That is the fact that lies at the center of this documentary. That is the fact that the September 2024 news cycle processed for approximately 72 hours before the next story arrived, and Marcellus Williams became a name that most of America no longer remembers. His case is not closed. The DNA profile on Leisha Gale's murder weapon has not been matched. The unknown male whose genetic material was found on the knife that killed her 43 times has not been identified. Somewhere that person still exists, and Marcellus Williams does not. Case 5. Emmanuel Littlejohn. 2 days after Marcellus Williams was executed in Missouri and Travis Mullis was executed in Texas, the week that would not end produced 2 more deaths. Alan Miller in Alabama and Emmanuel Littlejohn in Oklahoma. We have already told Miller's story. Now we tell Little John's. And to tell it properly, we need to start with a body called the Oklahoma Pardon and Parole Board, because that board is the reason this case matters beyond the crime itself, beyond the execution, beyond the legal record. The Oklahoma Pardon and Parole Board reviewed Emmanuel Littlejohn's case. They reviewed the evidence. They reviewed the trial record. They reviewed everything that had happened in the 32 years between the crime and the execution date. They deliberated. And at the end of that process, the board issued a formal recommendation. Spare this man's life. Oklahoma Governor Kevin Stitt read that recommendation. He overruled it. And Emmanuel Littlejohn was executed on September 26, 2024 at 10:17 a.m. Emmanuel Littlejohn was 20 years old on June 20, 1992, when he participated in a robbery at a store in Oklahoma City. During that robbery, the store's owner, Kenneth Mears, was shot and killed. Kenneth Mears was a working person, a business owner, someone who had built something, a store, a livelihood, a daily presence in a community, and who died at the hands of people who wanted what he had without working for it. His death was real. His family's loss was real, and they carried that loss for 32 years through a legal process that moved at the grinding, decade-spanning pace that capital cases always move. Littlejohn was convicted under Oklahoma's felony murder statute. This is a legal doctrine that holds all participants in a felony responsible for deaths that occurred during the commission of that felony, regardless of who physically pulled the trigger. His lawyers argued that Littlejohn was not the shooter, that the bullet that killed Kenneth Mears was fired by someone else who was present during the robbery, that Littlejohn's culpability, while real, he was part of the robbery, he was there, he participated, was legally and morally different from being the person who made the decision to fire the fatal shot. The felony murder rule does not make that distinction. Under Oklahoma law, it does not matter who pulled the trigger if you were part of the crime. You are equally liable. You can receive the death penalty. The Parole Board, Oklahoma's own official body, the one created specifically to evaluate these cases, found something in Littlejohn's record. In his case, in the 32 years between 1992 and 2024, that they believed was sufficient to recommend that his life be spared. We do not have the full internal deliberations of that board. What we have is the outcome, a formal recommendation of clemency, a recommendation that the governor is not legally required to follow, but one that exists precisely because the justice system recognizes that the legal verdict and the moral verdict are not always identical, that courts apply law, but clemency exists for the cases where applying the law produces a result that something, humanity, mercy, doubt, suggests should be reconsidered. Governor Stitt reconsidered it, and then he let the execution proceed. Emmanuel Littlejohn was executed by lethal injection at the Oklahoma State Penitentiary at 10:17 a.m. on September 26, 2024. He was 52 years old. He had been on death row for 30 years. He was the fifth execution of a week that had begun 6 days earlier, with South Carolina's first execution in 13 years. In 6 days, 5 states had carried out 5 executions. The pace of it, the density of it, 5 deaths in less than a week, was something that legal observers and human rights organizations noted immediately as historically unusual. The Guardian described it as a level of judicial killing not seen in America in 20 years. Kenneth Mears' family had waited 32 years. That wait was real. Their grief was real. Whatever complicated feelings they carried into September 26, 2024, and grief after 32 years is always complicated, always layered with things that cannot be summarized in a press release. Their loss was the foundation of everything. But Emmanuel Littlejohn's execution will also be remembered, and should be remembered, as the week's clearest example of how thoroughly the governor's office can override every other part of the legal process. A parole board exists. It reviewed the case. It made a recommendation. The governor overruled it with no explanation beyond his own judgment. One person, one decision. A life ended. That is the power a clemency decision holds. And in September 2024, Oklahoma's governor exercised it in the direction that required the least from him and the most from Emmanuel Littlejohn. 5 executions, 5 states, 6 days. South Carolina restarted its execution machine after 13 years and killed a man who had been waiting for it for 27. Texas executed a man who had stopped fighting it and called his own death a mercy. Missouri executed a man whose own prosecutors had asked the court to stop the execution. Oklahoma executed a man despite its parole board saying his life was worth sparing. And Alabama executed a man with a nitrogen gas mask, while witnesses described something that looked for 8 minutes like anything but the humane death the state had promised. And then the week ended. And the news cycle did what the news cycle does. It moved on. Other stories arrived. Other outrages displaced these ones. The names faded. The cases became references in academic articles and advocacy organization newsletters, rather than conversations that the country was actively having. But the questions did not fade. They cannot fade. They are structural questions about what the American death penalty system is and what it is for, and they do not disappear just because the national attention span moved somewhere else. Leisha Gale was stabbed 43 times. Irene Graves was shot at work. Kenneth Mears was killed during a robbery. Lee Holbrooks, Christopher Yancey, and Terry Jarvis were shot at their workplaces over rumors. Elijah Mullis was 3 months old. These were people, all of them, the victims and the executed both. Human beings who were born, who lived, who died, and whose deaths left behind damage that no execution date and no official press release ever fully accounts for. The families of the victims carried their losses for years before September 2024. They will carry them for years after. The executions did not end their grief. Nothing ends grief. What executions do, at best, on the most generous reading, is mark an ending. A formal, state-sanctioned full stop on a legal sentence that has been running for decades. Whether those full stops are worth what they cost, in time, in moral compromise, and the very real possibility that one of the 5 men executed that week should not have been, is the question that September 2024 keeps insisting on. America executed 5 people in 6 days. One of them may have been innocent. One was killed in a way that witnesses described as 8 minutes of visible distress. One asked to be killed. One was killed despite his state's own review body saying he should live. And one was killed by a state that had gone 13 years without executing anyone and then restarted the machine like it had simply been waiting for the paperwork to clear. This was 1 week. 1 week in 1 country. And almost nobody is still talking about it. 5 executions were carried out in the United States between September 20th to 26th, 2024. It was the highest concentration of state executions in a single week in nearly 2 decades. Marcellus Williams' case remains one of the most contested potential wrongful executions in modern American legal history. The DNA found on Leisha Gale's murder weapon has never been publicly matched to an identified individual. This documentary was produced for educational and public interest purposes. All information is sourced from court records, the Death Penalty Information Center, AP News, Al Jazeera, The Guardian, and verified news reporting.